If your VA disability claim has been denied, one of your appeal options is with a supplemental claim decision review request. A supplemental claim is filed at the agency of original jurisdiction, also known as the regional office, rather than the Board of Veterans' Appeals. A supplemental claim is a type of appeal in which you include new and relevant evidence with your appeal. These are two separate requirements for the evidence. It must be new and it must be relevant. But what does new and relevant mean? The new part of the requirement is fairly straightforward. To be considered new, the evidence must not have been part of your VA claims file at the time of the last decision. If it is a duplicate record or redundant, it is not considered new. New does not mean that the evidence did not exist at the time of the last decision. It just means that it was not in VA's possession then. Regarding new evidence, it is important to note that evidence that was added to the claims file after the last decision but before your supplemental claim can be new. You would either need to submit that evidence again to VA with your supplemental claim, or at the very least, you would need to identify this evidence in your VA claims file with enough detail so VA can locate it and consider it. But this is not considered redundant evidence because it was not there before the decision being appealed. So what about the second requirement that the evidence must be relevant? This one requires a bit more analysis and a little bit more detail. Under 38 CFR 3.2501, relevant evidence is information that tends to prove or disprove a matter at issue in a claim. A matter at issue is another way of saying something that is in dispute. To determine what issues are in dispute, you will need to look at the reasons VA denied the claim. Here's an example. If you're seeking service connection for PTSD and VA agrees that you had an in-service stressor event but denied for lack of a current diagnosis of PTSD, the evidence you submit with your supplemental claim needs to be related to a diagnosis. The in-service stressor is already conceded, meaning it's not in dispute. So additional evidence regarding the stressor event is not relevant. But if you read 38 CFR 3.2501 carefully, you will see another type of new and relevant evidence that allows for evidence related to an issue that is not in dispute. According to the regulation, relevant evidence also includes evidence that raises a theory of entitlement that was not previously addressed. If something was not addressed in the previous decision, then that has not been denied and is not in dispute or a matter at issue. But your new and relevant evidence can offer this alternative theory of service connection or entitlement. I won't get into that one for now, but think on that a little bit as to how evidence may provide a new path to service connection other than the theory you had already been operating under that was previously denied. I'll try to do another video soon diving a little deeper into that topic. In the meantime, if you need help with any type of appeal, feel free to reach out for a free consultation.